Hello, this is Kareesha Turner, your human rights barrister. Thank you for watching Kareesha Law. Please subscribe and like, and also hit that notification button so you do not miss out on my videos. Last week we were talking about children applying to be registered as British nationals. I summarised the court case which found the fee charged by the Home Office to be excessive, which means lots of children are unable to register to become British nationals. What else can be done until the Home Office reviews its fees? Well, write a petition to request that the profit element to be removed from the Home Office fee. You could also write to your MP and ask them to help. And also, perhaps something that needs to be reviewed is whether children who are vulnerable or looked after by local authorities should not be made to pay the fee. But if your child has not been here for 10 years but is born in the UK, what other options are there for them to regularise their stay? You'll be pleased to know that there is a provision in law that provides that a child may be granted leave to remain on the basis of the Article 8, where they are under the age of 18, they have lived continuously in the UK for at least 7 years, and it will not be reasonable to expect them to leave the UK. This does not make the child British, but the child becomes what we call a qualifying child in law, or for the purposes of the immigration rules. What does that mean? Simply, the child has lawful stay. Does that mean that the Home Office will not try to remove them, or will the Home Office find that it's reasonable for a qualifying child to leave the UK? From my experience, the Home Office's position in almost all cases seems to be that it's reasonable for the child to accompany their parents abroad. The Home Office has a guidance that sets out the factors that they consider before coming to such a dreadful conclusion. Some of the factors are things like whether the child should accompany their parents, and if it's in the best interest of the child to stay with their parents. That's common sense. Then there is the consideration of the wider family ties in the UK and country-specific information, and whether or not the child can integrate in that other country. All this boils down to evidence. Evidence, evidence, evidence. Just because you have a qualifying child does not mean that this is the end of your relationship with the Home Office. If you are making such an application, it's important to talk to a lawyer to have it done properly. I've had success with avoiding court and getting the Home Office to reconsider the application of parents when a qualifying child is involved. If you have more questions or would like to make an application for your child to be registered as a British national, or through make an application for the 7-year route, contact me or contact a lawyer. I hope this video was informative. Thank you for watching Kareesha Law.